So let's get started. We're going to talk today about UIM cases. UIM is underinsured motorists. I thought I would start out with a brief introduction. Like I said, Teddy and Chance are going to be joining us. The idea for these CLEs is to introduce some non-personal injury lawyers to some personal injury topics, so you guys can help screen for cases and make some money in areas that you don't normally practice. And two, to brush up on changes in the law for our folks that do lots of personal injury. So let's go to the first slide. So like I said earlier, no meeting in July. If you've not RSVP'd, please email Dennis, D-E-N-I-S, at herberttrial.com. If you don't, the state bar will not give you credit. But please, if you haven't RSVP'd, shoot Dennis an email with your bar number, and we'll make sure you get credit. Teddy and Chance, I've known Teddy for 5-8 years, and Chance for 10 or 15. Excellent lawyers who really does some great work in UIM stuff. After today's discussion, we're going to email you out a UIM kind of strategy packet. After we kind of figure out everything we covered, we're probably going to include a standard jury charge, a couple of cases that really hit the high points on this issue, maybe some voir dire topics, and maybe a brief summary of what we covered today. So we've got your email, and so we'll be looking in your email probably early next week for a packet of information that will just be kind of a refresher on this stuff and some of the case law you might argue to court. So the first part of this, I'm just going to introduce the topic and give you guys some basic information about finding a UIM case. UIM insurance is insurance you or your client buy that covers the negligent acts of another. So client calls up, I was in a car wreck, I didn't really get a copy of the police report, the person that hit me doesn't have any insurance or took off. You might think to yourself, well, there's no case there, sorry, can't help you, wish we could. Call me later when you've got a criminal case or a family law case. Well, the reality is the most important question to ask in a situation like that, or any PI case, is did you buy UIM insurance? A lot of people buy it and they just don't know. They're the only person that can make a claim on it. So ask them, even if it looks like there's no case there or you can't track down a defendant, ask your folks, did you buy MedPay? Did you buy PIP? Did you buy UIM? Did you buy UIM? They will probably tell you, I don't recall. Unless it's an engineer or a doctor, they always. If they don't know, simply get the phone number for their agent. 2-minute phone call and figure out if there's coverage or not. Finally, if an agent tells you that the insured does not have coverage, and it's Fred Loya or now defunct ACCC or any other cut rate insurance company, ask to see the declination letter. When your client buys coverage, they've got to sign a little waiver that says, I've been informed that I have the opportunity to buy UIM coverage at this rate, and I'm electing not to purchase it. I would say for those cut rate insurance companies like General and Fred Loya, they lie to me at least half the time. So when you call them and you say, did my client have UIM coverage? And they say, no, of course not. Say, okay, great, send me a copy of the letter. Because half the time they're totally full of crap and they do in fact have coverage. Next slide. Real quick, who is covered? That UIM policy is going to cover your insured, your client, any of his family members that may have been hit by another vehicle, your guy, and anybody in his car. That is really expansive coverage. Also gives you an opportunity to think about who else might have been in the car and also make a claim on that policy. You might be given the opportunity to sign up 2 clients instead of 1, or sign up 1, and if there's a potential conflict, you can get that other client over to Teddy. So ask your folks who all was in the car, and bear in mind that the coverage extends to anybody in the car, anybody in the household, and even if they got hit by another car. Make sense? All right. Last slide for me, I believe. What is the triggering event to get UIM coverage? It must be physical contact with a vehicle. there's kind of an anti-fraud little hook in the statute. You can't just say you got hit by a car. You can't just say a car swerved in front of me, I went into the median and smashed it up. You have to have physical contact with another vehicle or person or bicycle. Make sense? It's got to involve a car contacting something else. If you've seen Hands on a Hard Body, that's why you remember that. At least touching a car. Doesn't have to be your car.
And Kyle, can y'all hear me?
Yeah, I can hear you.
When y'all are ready, I have something to add to that, to the content. Well, one thing that everybody should remember, that with respect to the physical contact defense, it'll be a fact question. And so, you know, the jury charge would change a little bit. I've had a case where their main argument against coverage was that there was no physical contact. And I was able to make this a fact question. And to be honest with you, the good thing to do if you find yourself in this situation, and really any type of situation in a UM case where they're trying to leverage a strong point, I was able to get them to sign a Rule 11 agreement, agreeing that there was contact in exchange for not deposing their corporate representative. That's probably something that we'll talk about here in a minute, is that they really don't want to produce their corporate representative, hardly ever. There's case law now that says we get it, very limited. But just to think about it, when you're going into these UM cases and there's something weird, that's something that you can use as a bargaining chip. And to be honest with you, the corporate rep depot doesn't really help as much as everybody thinks it does. But it is something like, for instance, in that case, if I was looking at it, didn't know the law, I would have walked away from the case because I would have been like, there's no physical contact. But because I was able to find an opening and then later leverage it, the issue went away.
Thanks, Chance. That's actually the end of my portion of the presentation. If you can go to the next slide. I'm going to give Chance and Teddy, I'll start with Chance since he was talking, an opportunity to introduce themselves. Chance, will you tell us a little bit about your practice and what you've recently been dealing with, your recent successes with UIM? And then I'll kick it over to Teddy and introduce some of our discussion topics. Go ahead, Chance.
So I tried my first case in 2017, and it was very contentious litigation. I don't say that lightly. The guy retired after the case. He worked for Lori Weiss and Associates. His name was Andrew Petty. And we literally, it was a weird case for me because my client was like the most, high maintenance isn't the right way to describe him. He was a very heavy fellow, and he had $34,000 in medical, 2 surgical wrecks, which, I think it's safe to say he never had the surgeries. It was a third-party crash case with $100,000 in third-party coverage, low impact. And I got them to tender the $100,000 for the third party. And then I proceeded with the UIM case because my client had $300,000 in coverage and then $1 million excess on top of that. So we go to trial on it, and I get an $800,000 verdict. And the reason I tell you all about this is because the case is Weiss versus Wentworth. It was in the 152nd in Harris County. So to the extent you can access the Harris County database, you can go check my filings. And I think I'm confident to say that I litigated every issue that exists, from whether I got written consent to what a big part of my presentation today will be, and that's voir dire, and trying to really make sure the judge understood that I had to talk about insurance during the voir dire. So for people that are really interested in trying these cases or working them up, Weiss versus Wentworth is a good place to go if you want to look up and see kind of my filings and stuff. Because it got so contentious. I went and got the Brainerd jury charge from Polk County. I've tried, I think, 4 of these cases. I recently tried one in the 157th, and I didn't submit the medical. The client hadn't treated since 2018, and I got a $125,000 verdict with the $45,000 in attorney fees. Now, there were some unique situations because of a valet issue, but the policy was $100K. I'm going to talk to you all about how I look at stuff and how much fun I think these cases are. But yeah, so I'll turn it over to Teddy now.
Chance, where are you joining us from today?
I'm in Seaside on vacation, guys.
Can we all join you there in August for the next season?
You got it. Send me some cases.
All right, Teddy.
So I'm Edward Festeryga, and I'm a protege of Kyle. I now practice at Abraham Lockett. I'm one of Kyle's proteges. I will say I tried a case recently also in the 157 that had some fun facts, but I'm also a protege of Chance Mcmillan, who I think is one of the lead people who I am doing cases in the spirit and some strategies on how to deal with the issues that come up. The case that I tried was an interesting case in the fact that I had two clients with significant pre-existing conditions who hadn't treated in 6 years. So it was less UIM focused than it was how do I deal with some of the problems that I'm facing with my own clients and the damage model they have. But what I was able to do was certainly leverage the context that a UIM case presents to be creative in how I told that story and to have a villain. So I had a non-dispute liability case where I pretty clear back and spent the impact. These guys were literally getting treatment in the same parts of the body, 2 weeks before the accident, and they hadn't treated in 6 years, playing racquetball and working pretty hard labor jobs up until basically the time of trial. So I mean, there was nothing to do with that. My guy was doing cartwheels in his medical records. It's like, how are we going to claim something on this case? How am I going to go with the significant or legitimate damage? So I had some interesting strategies as to how I approached that throughout the whole trial process. I did not submit any past medical. I got a $479,000 verdict and some change on a $11,000 pretrial offer. So that was pretty good. Again, that's two guys. You guys shouldn't have got smashed. But yeah, very creative with the voir dire. I think voir dire is one of the best areas where I tried a very different approach where I wasn't trying to eliminate the cause, but really much more inclusive approach, which I think is very beneficial in the right context. And then thought of some useful themes and some useful strategies as to how I actually approach the case itself. And then work that all the way through my opening and my closing. I took my clients on the red. It's not just liability, so I had nobody to beat up but my clients. So I think you should have done that.
Thanks, Teddy. Let's start with kind of our first topic. So on a UIM case, you kind of have to prove the case within the case. You got to prove that there was negligence on the part of the defendant that caused the wreck. Chance or Teddy, what do you need to present at trial to get over that first hurdle? What do you need to think about presenting by way of proving the case within the case?
Chance, you dive on that one.
Yeah, so what I would say is a lot of people get nervous about UIM cases because I think they think of the horror story that can happen, and it can happen if you don't know what you're doing. And that's the defense getting in a situation where they're taking insurance out of it. The jury charge in a traditional UIM case, if you don't have some weird issue like the contact situation, is going to be the same jury charge in any kind of auto accident case. It's going to be a negligence question. I've never had a trial where the negligence question they didn't stipulate to at the very beginning, or I was in a position to get a directed verdict after the presentation of the evidence. So it always comes to damages. But it's the same concept as with the traditional car wreck case. You're going to have a negligence question and the damages question. Now, a lot of times that's where people kind of get messed up. And it's because they think too much about it. They think that, well, okay, what about the insurance company? And the fact of the matter is the case law and the way that it's been set up in Harris County and other places around the state. And I've actually went and talked to a lot of people and gotten transcripts. And actually in the Weiss versus Wentworth case, I filed a brief where I utilized multiple voir dires from across the state that showed, that those lawyers were permitted to talk about insurance during the voir dire. But I wouldn't look at it as much as a case within a case, because by the time you get to trial, there's going to be there's a stipulation that there's a policy that's in effect, or they would have to try to fight that early on. Whether the driver is uninsured or underinsured is actually on the insurance company to prove. That's one of those benefits to the way the law developed. So I've never had it where that was a question. The only questions the juries are ever asked to determine are the negligence and damages associated with your client's injury. And from there, knowing that that's the way you're going to handle it, you just take the fact that it's an insurance company and the fact that your client had, an insurance policy, and that becomes kind of ancillary in the background, but very prevalent. That's where your story comes out of. But it's not a case within a case. You're just proving, if you have to, the negligence of the uninsured or underinsured driver and the damages, and then think of it as truth prevails, because this isn't about a third party. This is ultimately about an insurance company, and that has to be front and center in your case.
So to prove up that issue, you just have your client come up there and tell the story about how the wreck happened?
Right. To the extent, like I said, I think most people, if you're getting in a position where you're trying the case, certainly from an underinsured motorist standpoint, liability is pretty much established. In an uninsured motorist case where, it's a hit and run, right? Or it's some deadbeat that didn't have insurance, you're just, if I look at it like this, if you're called to prove the negligence, if it's, something that's up in the air, then I guess you have to roll up and pull up you have to roll up your sleeves and prove the negligence of the uninsured or underinsured driver. Now, while you're doing that, you're fucking up the insurance company the whole time, because if that's, they're essentially calling your client a liar. But if you're pressed to do it, then yeah, you would say like in my case in Weiss versus Wentworth, they stipulate a liability, but when I would talk about the crash or whatever, I would say, Mr. Wentworth hit you from behind, and in your opinion, he's an underinsured driver, right? You're continuing to put that in there and look at it like you're telling the truth, like where the insurance company is trying to hide the fact that, they're, I guess if they're allowed to run rampant, they'll try to act like they're defending the uninsured or underinsured driver. But anything that they do, anything that your insurance company does in this trial is just walking right into a landmine. If they're going to come in there and say your client, if it's a car crash case and they're saying that the other side or that the uninsured driver wasn't negligent, that's a loaded gun for them. But to answer your question, yeah, if forced to do it, then I would just walk through and prove the negligence with a car crash. If the uninsured or uninsured driver never testifies, then that's just your client. What the lawyer says for Allstate, that isn't evidence. So if you have a situation where it's only your client testifying to what happened, well, that's the only evidence in the case, and that's how you would get a directed verdict.
Right. Practically speaking, who's showing up? It's your client, and that's going to be it. There's more people there to testify. I think the key point, and Chase has referenced this really well, but the defendant is the insurance company. It's your own client's insured. What you don't want to have is a situation where you can't reference that again and again. And that's why the Weiss case, the chance reference is so good, because it puts the onus squarely on the fact that this is a case against the insurance company. It is the insurance company that's here arguing. It's the insurance company that's here defending. It's the insurance company that's here trying to claim that somehow its own insured acted unreasonably or is not hurt. It's ridiculous. And so long as you can fight off, like you can have a motion to change the case caption, there's a number of things you can do, but you can never be locked in a position where you are not referencing this case against the insurance company, against their own insurance.
So let's talk about that second element. You guys have talked about submitting the medicals or not submitting the medicals. What are you seeing that needs to be done to most effectively present damages in excess of the underlying policy? And how do you make the decision to submit meds or not submit meds?
Well, I think that's a broader topic of conversation. Even the just UIM cases. I think the school of thought that's developed recently, a lot of the juror cognitive sciences studies suggest that you never want to introduce low numbers, meaning we're passing meds, even introducing past meds, unless you've got damages or past meds in the order of hundreds of thousands of dollars in past meds. Don't even introduce them. They do nothing for you but anchor down the potential damage model that you might have. So in the case that I tried, I did not submit past minutes, but I was able to introduce the cost of future surgery. So I had 2 future surgeries. One was, I think, 135. It was a one-level fusion. Another one was 175. So 3-level fusion. That was the only economic damage that I submitted.
Are you able to submit pain and suffering damages?
Of course. And all you do is have to, you think of your theory, develop your story of what you want to talk about with clients. And that's a conversation that you have with your clients as to how you tell that story. Pain, suffering, mental language, and physical limitation, non-economic damages, sir. But if you don't submit $34,000 or $50,000 in past meds, well, then the jurors are going to be forced to consider what we have no other evidence. So what is it in our lives? What is that for? And that's where you are creative and talk about in voir dire and in closing. How do you put value on these things in your lives? I think that's where you have to have some strategies at least. But those are, I mean, that's universal in the practice of personal injury. That's not unique to uninsured motorist claims.
James,
Yeah.
add to that.
Yeah. So what I would say, and I know this happens a lot of times when I talk about the UM, is, one thing that everybody needs to understand is that the policy, it can be said in front of the jury that a policy exists, but the policy limits are never come in. So sometimes I'll hear people and they'll be talking about, like, should I ask over the policy? Should I not? Like, what the policy limits are by the time you get to trial, that doesn't have shit to do with what you're going to ask, other than you want to make sure and be above it. Like, and I'll tell you, every time I've tried a UIM case, I mean, this one I just tried, I asked for like 2.7 million. My advice to people that are going to try these cases are that you have a very, very real villain that everybody hates. Everybody fucking hates insurance companies. They hate insurance companies more than they hate lawyers. So everybody's going to have a bad experience. So in voir dire, I'm always trying to, I've tried it both ways, where I go the traditional way in a UM case and I focus on trying to strike people. And then the other way where I really focus top heavy on just getting people pissed off about insurance. And I'll say that getting people pissed off against insurance, in my opinion, is the way to go. So you have this real life villain. In my case that I just tried, the guy just hadn't treated very much. He hadn't treated since 2018. It was a terrible crash, but he just didn't have, he was fine. I mean, he was fine. So what I ended up doing was I ditched the billing. And then of course I didn't call a doctor either. And I walked through all the medical to get my pain and suffering mental anguish. And then I just got creative and asked for 2.7 million. I had to beat 100,000, And so my thinking is, if I do my job and get them fired up and hating insurance companies, then I'm going to be able to beat that amount. So I asked for the moon and stars, and I want a jury to be like, wow, that is way too much. I'm not going to give him 2.7. I'll give him $1 million though. And I'm crushing the policy, So that's what I would say, is that when you have in trial in general, what the UIM cases do is they give you a real life villain, bad guy to point to and say, look at these whereas other cases where you're trying to case John Smith versus Tom Smith, just some guy. So when it comes to damages, what I try to do in a case is just focus everything, look at my client's injuries, Let's talk about the insurance company. 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 And then I ask for a big number.
Real quick, what are your 1 or 2 best voir dire questions that you got to do in every case?
Dennis, can you pull up my voir dire? I have it if you guys want to see the PowerPoint.
I can provide it to anybody else.
I'm happy to give you my opening and my voir dire and the other letters that I sent out. So I voir dire on who knows this insurance company, anybody have with this insurance company, or anybody ever had an issue, who's had issues with their insurance. One other thing that I do, because I like to introduce big numbers, I go, here, this is Allstate publicly traded. Does anybody have a financial interest in this insurance company? Does anybody have a financial interest in an insurance company? Does everybody know that Allstate is an insurance company that makes money by taking people's premiums and investing those premiums, and they actually make more money when they actually pay out less? They get earned income on premiums they don't have to pay out. Everybody understand that? Everybody understand that Allstate's the insurance industry did 22 billion in revenue, some ridiculous numbers like that. But everybody understand, what Allstate did in revenue last year? They can object it if they want in voir dire, but I get into it.
So you just say terrible things. I just try and strike anybody.
That's absolutely right.
I'm striking people. Why? Because what you have is people who hate insurance, who've had bad So go through and you can, yeah, click through the next slide. I'll show you my sequence. Just click through it. You can see how I set it up. So you can't do all snake. You can't do anything ridiculous, but you know, you got your basic stuff. You tell your jurors what the case is about. You run a little story. And then my first slide will be going. We keep our promises, and insurance contracts with promise to be there when we need the most, fundamentally. And so I started dropping it in with my jurors right away, my nearman anyway. Anybody disagree with that? You know, we don't keep our promises. If you strongly disagree, radar on that. Everybody thinks that you can make a promise, you can keep it. You do that for something. Go to the next one. So I explained what the case is right away. Next slide. Tell them what it is. Next slide. Next slide. Allstate. Who are they? Allstate stock, NYSE, Allstate. We have financial interest. It's not complicated. It's not complicated, but you give them some visuals. It guides you through the board hire. You start with the big numbers and issue the insurance. You can go to the next. We don't need to do all these, but you know, you guys might like the next slide. Who likes my preponderance cat slide? The next one. Were you using this one? Yeah. Yeah. There's my cat slide. So we love that. And I sang a song in board hire because it's an inclusive board hire, so you have to do weird things. You try to build a tribe with people, so you do some different things that are a little bit offbeat. And the insurance company lawyer, professors are sitting there going, "What has happened? What do we do? How do we stop this?"
What's the song?
Sweet dreams are made.
That's terrible.
And so, you know, you tell people whatever it is, but then I had obviously pre-existing conditions in my case. So it was, you know, well, hold on, do we take people as we find them? Do we value them or their injuries, or how do we think about that? And I had a few different sort of stories that I used to spell that out, but it was very much inclusive. It was not a challenge for cause sort of or dire. And you don't need to in the UIM context because, as Chance has said, you've got someone that people hate. You've got Colossus. You've got this entity that everybody's had bad experiences with at some point, or knows someone has at some point. And so when we started going with, because everybody knows who Allstate is, that they're publicly traded, there was a great back and forth between our panel of people who had bad experiences, who were in a bad place, who just absolutely dumped on Allstate for about 15 minutes and did my job for me before I even had to open.
Awesome. Thanks. Chance, you have anything to add to that quickly?
Yeah, just that, I mean, what Teddy said, I mean, I've done it both ways. This last time I did it where I really, because in other cases I try, you know, you're trying not to find jurors that agree with you. You're trying to find jurors that go against you, and then working as a technician to get them off to your jury. And in this last one I did it the way that I wouldn't do it again. And I mean, I still had my UIM beat up moment, but it was at the end of the board hire. When I do my other ones and the other ones I've done, I just come out the bat. I mean, very conversational. Who here knows what underinsured motorist is? Raise your hand. They raise their hand. Man, what is underinsured motorist? Tell me. I say, that's right. That's correct. That's right. And who's your insurance company? Okay. Well, tell me this, ma'am. How would you feel about your insurance company making you wait 5 years before you get paid on a claim? Would that make you happy? No. Okay, wouldn't make me happy either. Everybody else, raise your hand. If it took you 5 years to get your case against your insurance company resolved, would that make you upset? Raise your hand. And you just kind of, what I would do if I had an hour-long board hire is I'd commit 40 of it to just fucking bashing the insurance company, and then I'd hopefully identify the individuals who I knew for whatever reason were bad for me, and then I'd go after them. And these people, you can really make it hard for the insurance company. You can inoculate them and protect them. Usually you're setting up your strikes for cause. Well, if you get some people you really like, you can be offensive. You can take steps to make sure that you're protecting them before you pass. So it's just a different board hire. It's easier, but you got to be conversational during this one. You can't come off and just try to go after people, because they're going to want to if they want to tell you a bad story and it takes 5 minutes, fucking let them talk for 5 minutes about how shitty the insurance company was to them, and then at the end say, but you can be objective, right? Yeah, I mean, you're not going to hold that against them, right? Okay.
That's great stuff. We got about 25 minutes left, so I'm going to zip through. Some of these are short. Does the barrier get to pretend that they represent the defendant, the underlying defendant?
No, there's a case out of Corpus Christi that says it's fraud.
Tell me about attorney's fees. Proving them up, how to plead them and how you're presenting that and how that impacts your damage model.
You got attorney's fees, Chance, go ahead.
Yeah, so, some of us have been doing this for a while, knew that this was a possibility. The declaratory judgments were going to go like the 2017 Weiss case. I pled it as a deck action. So we kind of knew this was a possibility. I'll be honest with you, didn't think it would ever fucking happen, but it has. Allstate v. Irwin came out. So, the problem is that there's a lot of case law out there dealing with attorney fees. And for those, probably like people like me that have always been a personal injury lawyer, I had to kind of learn what that meant. Like anytime there's an opinion that comes out about attorney fees, it ain't good for us. So, what I would say is this: you should be keeping logs with your hours, but in the event you're not, and you get assigned to trial, for instance, you have 2 weeks before trial, start keeping your hours then, and be meticulous about it. You'll be surprised how much $500 an hour can rack up. My opinion with respect to Allstate v. Irwin and attorney fees is that the cases that so many of us who have always been here, working men plaintiff lawyers that have, got big hits from time to time, but they're also just kind of doing what they can to keep going and building a practice. The cases where you have $35,000 in medical and $30,000 third party policies, and then a $30,000 policy, to me, you get the $30,000 now. To me, if they're going to make me go to trial, I get the $100,000 case. So I hope everybody understands what I'm saying. I just said that, usually, let's say it's a $30,000 in medical and you have a $30,000 third party. Back in the day, 2 years ago, if the insurance company, the offered you $2,000, $5,000, you have to think about it. No more. You get the consent. If you're going to work your case up to trial, you're going to get that $30,000. You're going to be able to get them in a position where that $30,000 policy needs to get paid, or your attorney fees will be way above it. So, the way UIM policies work now, at least for me, if I get a case where there's $30,000 in UIM or $100,000 in UIM, I think they need to pay me it, or my $500 an hour in attorney fees is going to eat it up anyway.
Are those attorney's fees part of your damages?
Yes. So, what you do is you plead, you have to, now that we're in the 2021, we have to write reports, expert reports. So in every UIM case, I would go ahead and designate myself or somebody you trust. I have somebody, I testified in mine, which you can absolutely do, but I have somebody now that I'll call, who's a little more, grayer hair than me. But it is part of your damage model. It's not paid through the policy. That's important. So you can have a $30,000 policy, have that tendered, and have $150,000 in attorney fees, and State Farm has to pay the $150 in attorney fees. So there's no stowers in a case, but you can utilize the attorney fee mechanism to really leverage against them.
So what I do, Abraham Watkins, is we send out a letter right away. Right after we get consent to settle, I send out a letter saying, here's what we anticipate, what our attorney's fees are going to be, here's where we may have built at this point. And then the mechanism, the actual method that I use to track is Google Sheets, with a spreadsheet. There's two key cases on point attorney's fees that I'm aware of in my research on this issue. But there are Anderson factors are with those. And the more recent one is Warman's. And take a look at both of those cases, but they basically spell out how you can, how it is you have to go about proving up the attorney's fees, which is documented. But you take a Google Sheet, we use Google Sheets for it. It helps keep track of time. So we go through, who's the attorney working on it, what's the task. We're pretty specific, time in, time out, rate, billable, and then how much it is. I actually send the letter and send the sheet right away. And we say, here's where it's at. Here's what it looks like. We're compliant with our Anderson, we're compliant with the Warman's. Somebody's going to go ahead and testify on behalf of the attorney. Either me as the attorney, and I'll designate myself as the expert, and then I'll bring somebody else with me, and then they'll take me on direct. Or we bring some, you designate somebody else as an expert to do it for you. And I'm happy again to provide that letter as well as.
We already have that. We'll give that.
So, yeah.
If the third party case settles for less than policy, can I still bring a UIM case?
Yes.
Yeah.
Yes, they get a credit.
Man in the back.
Just on the attorney's fees, like our contract is just a straight contingency contract, but then do we need to specify, do we have an addendum on UIM cases to have attorney's fees per hour, that hourly rate, so that that can be proved up?
You're gonna need to establish the reasonable hourly rate for you. So whatever that might be, $500 an hour, whatever it might be, and you're gonna have to justify why it's reasonable for you. So I found the case that I tried, it was not actually filed with deck action to start with. It came to me way late. I amended right away, did a deck action, so I was going to bring attorney's fees, designated myself as an expert, provided my seat, it says all about what I am, it said what my reasonable hourly rate would be. And so that's just included my designation and everything else. Well, if you were to do it, I didn't want to do it frankly. 4-year lawyer, who had basically a 1-year lawyer who's been taking on the record. I don't want to put this on the record forever talking about.
Are you with $110 an hour?
My $700 an hour attorney. I don't know if I can do this, but that's how you go about it.
Did that answer your question?
It did. We just got an RFP from,
Yeah, I know. They ask you to provide your contract and all that.
Right.
stuff. Chance
So-
is that admissible? Your
Yeah.
contract that talks about a 40% contingency?
I think that you have to get, first of all, I'd fight them on it anyway, just cause, but I think you have to give them the contract. And I guess they could take the angle that your contract, you weren't anticipating this. Here's the deal, and they put me on the stand and they crossed me. And I mean, it's not going to go good for them, right? Like, Mr. Mcmillan, it cost you want $103,000 in attorney fees for work that you did after April 25th. I mean, is that what you're telling the jury? Yes, I'm telling them that's what it takes to hold y'all responsible, State Farm. Yeah. I mean, it's loaded. So I guess you could, I would go, that'd be something for me that I would make them compel with the court. But then once they got it, I would be like, who gives a shit? The law is clear. All say B. Irwin. It's not really a situation. If you're allowing them to kind of get in a position where they're attacking you because your contract doesn't say it, then I just think you have to take it head on. Yeah, well, on direct, what does Allstate v. Irwin, Mr. Mcmillan? It was a case that says that insurance companies need to pay their insureds, and as a penalty, if they don't, the jury can award reasonable attorney fees. Mr. Mcmillan, what are your reasonable attorney fees in this case? $130,000.
Thanks. Okay, so what discovery should we be trying to get out of these defendants, if any? And do we need to take a corporate FFO? What is the general goal for discovery against the carrier?
Go ahead, Chance.
So with respect to, I would say, here's the deal, and I'm not going to repeat this a lot. There isn't much discovery you can do. These cases are really enticing to a real trial lawyer, because you can present your plaintiff, get your medical and billing in admissible form, and be like, it's go time. Like, I mean, I really wish that was the way that this worked more times. It takes too long to get to trial with these. You're really wasting a lot. I mean, look, I have some standard discovery I send out, and they object to everything, and I don't compel it because I'm not trying to have a bad faith argument. And that's really all the discoveries plan to do. The only things you got to prove at trial are the negligence of the driver and then the damages arising from it. So send the discovery out, but don't let that be a hindrance in any way. Know that if you have to compel it, you're not really going to get very far. There's a case called USAA that recently came out that made it clear from the Texas Supreme Court that we get to depose their corporate rep on very limited topics. It's like the valuation of damages, their theories, and affirmative defenses pled. So, I mean, you can go do that depot, but that's it. I mean, it lays out the parameters. For me, the corporate rep depot is kind of useless. I mean, I've done it a bunch. I've tried to get them to go to trial. I've never heard of anybody really getting them to trial. I don't know why, but for some reason that always fails. But I guess what I'm saying is, you're the one that holds the keys. You get your plaintiff deposed, you can technically be on a fast track. There isn't a lot of discovery you can do with written discovery because everything would be on bad faith.
I tried to subpoena Allstate's adjustment to show up in my trial. There's a 1-7. Like, what is he going to say? Well, talk about their policies, talk about their knowledge, how to lay claims.
That really goes to bad faith.
But it goes to that way. It's the main thing. I tried to sort of shoehorn it into a damage argument. It's part of my client's medical language. The issues that they're dealing with, they're paying suffering because they haven't been able to get a surgery to get the symptoms, and also knows that. She said, shut the fuck up. He told me to go away. So, yeah, I tried it. Again, I don't know if you can draw much blood from that stone. The value, I think, of those corporate rep depositions of the carrier, like, go for it, track it. You know, prep that deposition. It's part of your D model, part of your image model at that point, because attorney's fees will recover. So why not take it? Why not put a little pressure on it? Prep for it, ask them some questions, figure out if you can get some good stuff up, and nothing that you get, but then extract your fees and go down the line.
Another thing to do too, and I did in the last trial, and I don't know how effective it was, but you know, I tried to subpoena their corporate rep to trial. There's a case that says you can't subpoena a corporate representative. Like, if you know their name, you can, but you can't be like State Farm's corporate rep. But so the subpoena didn't work, but they didn't have anybody at trial. But I still stood up. First witness said, you know, plaintiff calls State Farm's corporate representative. And everybody looked at me and I looked at them, and we all looked at each other, you know, and they like waved their shoulders when we walked to talk to Garrison. And she was like, you know, what are you doing? And I was like, what do you mean, what am I doing? I mean, why the fuck can't I do that? Like, where the fuck is he? You know? So just think about that. Like, you might have to eat that, but you know, if they don't want to fucking have him there, make a big deal out of it, you know, make a big deal. Like, you know, I mean, there's no reason you can't stand up and say, you know, plaintiff calls State Farm's corporate representative, and then let them look at you and be awkward. And then in closing, be like, that was weird, right? That was me showing y'all, that was me showing y'all they're not here, you know?
Do you only do that if you previously sent out a subpoena?
I mean, I think do it anyway. Just fuck it.
No, honestly, the best part of these cases is that the pageantry of UIM case is the best part. Like, you can just put on a great production. Because there typically isn't a third-party defendant driver. It's just the insurance company. And you can do all kinds of weird things to make it look ridiculous, because it is ridiculous. And
Yeah,
your jurors.
Do your
When I-
underlying defendants ever bring in deposition testimony or evidence from the underlying case on the negligence issue or anything else?
Not in my experience.
No chance.
Sorry, ask the question again about what?
Did your UIM defense lawyers ever bring in deposition testimony or transcripts or anything from the underlying?
No, I mean, it's just, and it's one of those things that I think is, you know, everybody sits around and thinks about. But I mean, I've never had, by the time you get there, you know, usually, I mean, every time I've ever done it, the liability is just not an issue. It just isn't. And it's just, you can see why. Let's say it's an uninsured motorist case, hit and run, you know, you have contact, like it really is a loaded gun. Like if they came in there and fought that, I'd be like, you know, I'd get in closing and be like, they're here calling him a liar, you know, it would just be a bad spot for them to be in. With the corporate rep thing though, it was funny because I go up there to Garrison and she goes, what are you doing? I go, call the corporate rep. And she said, well, he's not here. I go, well, let's call that guy right there. And Jill Shine goes, you want to call my paralegal to the stand? And I was like, well, you know, he could be the corporate rep.
I like the chance. Never let your ability to argue be limited by the law or the facts.
or the people in the room.
So let me switch gears just a little bit. Have you seen defendants do anything good that we should walk out for? Are there any real good defense side tricks that people should be aware about?
No.
No.
I would say in this last case I tried, you know, it's going to sound crazy, but like, so my guy was hit by a drunk driver, and the drunk driver was a fuck up. You know, he was nowhere to be found. State Farm, I look back and what my answer would be this: you want to keep everything, all the bad acts on the insurance company as much as you can. Looking back at that trial, the fact that the defendant was drunk, like, allowed State Farm to kind of distance himself from the fact that he was an uninsured motorist. Like, you know, it wasn't our fault he was drunk. He's a drunk driver. You know, so what I would say is you really want to keep the bad guy in the right spot. You know, if you don't want two bad guys. So if I could redo that case, it was a really bad crash, I would have agreed to keep the drunk out. I would just been like, let's keep it out. Let's focus on y'all's. Say that again.
All right.
Say that again.
We got about 10 minutes left. We hit a couple of these before we wrap up. I'm sorry. Go ahead.
I'm just, look, is you have cases, it's a damages contest at the end of the day, because like Chance said, they're gonna stipulate the liability, at that point, it's just like, well, you aren't perfect. And everybody who's in this room is trying to percentage knows the same arguments about having gone to treatment, gap in treatment, pre-existing condition, lingering, whatever it might be. I mean, there's nothing unique about that. Not anything that they're doing. And what they're trying to do is excuse themselves from having to do what they promised to do, which is be there at the time that somebody needs it most. That coverage, they can take care of themselves. You can always come back. They're just trying to say, we won't give you what you pay for and you promised to provide.
We've covered a lot of stuff that would come up in pretrial. Are there any major pretrial concerns that you want to make sure you're planning for and are loaded for bear when you walk into pretrial with court? Chance, I'm asking that to you since you wrote.
Yeah, so here's what I would say to everybody who's about to try a UM case, especially since we have a lot of newer judges on the bench in Harris County. You have to you want to find out before the date of pretrial what the judge's temperature is with respect to if they're going to allow you to get into the UM and the underinsured motorist portion of the voir dire. This is probably the most important thing that I would say take away from me speaking at this is, you want to find out, because some judges will say we're not allowed to talk about insurance. They're wrong. And you don't want to have that fight on the day of pretrial or the day of trial. I've actually had it where the judge told me I couldn't talk about insurance, and it freaked me the fuck out. So I went and wrote a brief and went across the state and found 4 other voir dires, one in his court where he allowed them to talk about uninsured motorists. And I showed it to him because it was such a big fight. So for the pretrial concerns, the most important thing out of every UIM case is that you're creating your billing, that your billing has legs. So you want to find out somehow in a pretrial hearing, status conference, random ass status conference if you have to, if the judge is understands what you're going to be doing in voir dire, because if not, that's where the fight is. If they get that wrong and you're not able to really create your villain, then you're not going to be as successful as we've talked about.
So if I get a judgment way in excess of the first party policy and the third party policy, is there anything I need to do to make sure I get paid that? Do I get all that money? It's not a Stour situation. Explain that to us.
So with respect to, there is no Stours in a UM. That's why the attorney fees has, nerds like me all excited, because you can leverage that. So I got a $400,000 verdict in a UM case pre-Allstate v. Irwin, and it got remitted down to 50,000. Go about your day. So that's why you need to be really focusing on building up your attorney fees to leverage it, or if they make you try it, you get paid. If you have a situation where you have a third party, then and you can Stourize, then you do that and you either abate the UM or see if they can settle it. I've had a situation where they wouldn't settle the third party, but they wanted to offer me something on the UM, same insurance company. And I ended up settling with the UM and then just Stourizing. So you need to be smart about that.
So my actual damages in the UIM case are capped at the value of the policy, but my attorney's fees can be in excess of that. Is that what you're saying?
Yes.
So it could be $50,000 plus all my attorneys, theoretically.
Could definitely be that. They'll argue there's, case law says that there's time, not UM case law, but attorney fee case law about, that they need to consider the amount of damages. But you could technically have 50,000 in policy, hit that, and 200,000 in attorney fees, and they're on the hook. Judge's discretion.
But I got 800 in meds and 100 third party, 50 first party. I get that 150 and that's it.
That's well, that actually go to.
Yes.
You get those 100,000, whatever it is that attorneys fees you're arguing. Can you break down that, or do you still get the contingency from your clients? What do you guys done in those situations?
Yeah. You get simply not that. The contingency is still there. We made no, to answer your question earlier, we made no proviso that there would be an offset because we've got attorney's fees that wouldn't allow for recovery on the contingency.
We're just billing on the gross, you're 40% anyway.
Yeah.
Fair enough.
Part of the deal is too, is I guess, I'm trying to think about the question too, is we would never allow a windfall to insurance company. They just pay more. You're saying for the benefit of the client, there's some sort of offset to the client because we need to recover our attorney's fees versus what we do. You can negotiate with the client all you want. That's always your power, negotiating the fee. Yeah. I mean, maybe you want to have a client, you want to read a testimony, go ahead and pay your fee and get those attorney's fees. But you made your contract and part of the action. Nothing else beyond that.
Ethics note, don't ratchet up the agreement after you've already signed them up. That's a bad practice. A prima facie fraud case and a violation. Does that make sense? Like you can always negotiate down, but you can't say, I got the lion's share of your verdict, attorney's fees, and those are mine. Absolutely bad. Okay. Guys, we've talked about a lot of new changes in the law. Allstate v. Irwin and some of the attorney's fees new case law. Is there any other changes in the case law in the last couple of years that we should highlight or think about and make sure we add to the packet? Or are those two issues kind of it?
Those are the highlights.
Chance, anything to add on that?
Nope, Allstate v. Irwin, and then the USAA case dealing with really defining the topics that you can handle with respect to the corporate rep depot are the only things I would say.
Got it. You guys have any questions before we kind of wrap up the last couple of those? Yeah, Rumble.
Is contact absolutely necessary? Suppose there's somebody swerves out the way, there's an accident report. It shows that there was no contact, but somebody was swerving, pulls out and hurt somebody.
My understanding is there has to be contact, Chance or
Yeah, that's correct. So just think of it like this, guys. I mean, look at it from a common sense standpoint, I guess from the insurance company side. If there is no contact, then they'd be in a situation where they're having to litigate every time someone gets in a single vehicle crash, the phantom vehicle that cut into me but didn't hit me. So the case law is clear. You got to have contact.
Let me run through these last couple slides, make sure I hit everything we want to hit. Not working. All right. Like I said, no meeting in July. Let me sum up. Any questions? You hit all the big stuff? No? Okay. Next slide. See you guys in August. I think that's it. So one of the great things about this CLE, there's gonna be margaritas upstairs, is we actually have a lot of folks, a lot of different areas of practice. If you're free for a little while, come on upstairs, have a cocktail and some fajitas. We've got family lawyers, criminal lawyers. Mark Suit over here is a defense lawyer. If he shows up in one of your cases that's UIM, file a motion to have him excluded from the case. He'll probably consent to that. I've known Mark since law school. He's really one of my favorite lawyers. You're lucky if you get a case against him. But if you have a chance to come upstairs, introduce yourself to everybody else. It's an opportunity to talk with folks that don't maybe necessarily practice in your area of the law. I'm going to send out that email before you're done. Let me say thanks. We had a couple of sponsors. Oasis Financial, they do lending for medical stuff. They do lending for PI cases. They've been really kind and generous to buy us lunch and some cocktails. Also, Pipkin's Investigations. They're actually pretty helpful for not just PI cases, sometimes for family cases, sometimes for criminal cases. They do background checks. They do all sorts of surveillance and investigations. They've also been really kind sponsors of ours. Also, Chance, thanks for joining us on your, I'm not sure if you're on vacation or if you just have prepared to Florida to live the life of a hermit. But thanks for joining us. I really appreciate it. And Teddy, what was the name of that moose case?
The moose case? The moose jaw case?
Moose roar?
Roar moose.
Roar moose. So Teddy's originally from Canada. Roar moose was his nickname in college. So Teddy, I really appreciate you spending your time with us. Thanks very much. You guys did a great job. Thanks you guys for coming. I haven't met you before. Please grab me on the way out so I can chat with you, just introduce myself. But with no further ado, please go get as much tequila and limes as you feel like the Constitution can handle. So thank you guys for coming.